education production brought to you by the Bar Association of Montgomery County and the Montgomery County, Maryland Bar Foundation. The program is designed to provide you with general information regarding your rights and obligations under the law. It is not intended as specific legal advice. You should discuss the facts and circumstances of any particular matter with your own attorney and obtain advice specific to your case. The participants are local attorneys who have volunteered their time to bring you this program. We hope you find it informative and beneficial.
Welcome to Law School for the Public. My name is David Schoenfeld, and I'm a partner with the law firm of Bonner, Kiernan, Treback, and Crociata. Unfortunately, injuries occur every day at work. Those injuries affect not only the injured worker, but his or her family as well. Unless you've been involved in the process, you may not be familiar with workers' compensation insurance. It's very different than automobile or homeowners insurance. Do you have to pay for the insurance? Are there deductibles? Can you pick your own doctor? What are the employer's responsibilities? Will you have to go to a hearing? Can you get paid for pain and suffering? Do you need a lawyer? We are fortunate to have with us two guests who deal with these issues every day. Gretchen Rogers is a partner at Bourbon, Sobin, Gross, Feldman, and Darby. Gretchen's practice focuses on personal injury and workers' compensation. Gretchen obtained her JD from the University of Baltimore School of Law and an MBA from the University of Baltimore Merrick School of Business. Gretchen served as a panelist for the Tort Trial and Insurance Practice section of the ABA, served as a moderator for the Bar Association presentation on the AMA guides, and as a council member for the Maryland Negligence and Workers' Compensation Council. Jonathan Marlin received his Juris Doctor from Suffolk University Law School and has been serving the defense community in workers' compensation matters for over 8 years. He represents national and local carriers and self-insureds as well. Jonathan provides seminars to his clients on other aspects important to the defense community. Gretchen, Jonathan, welcome to you both.
Thank you for having us.
Thank you. Gretchen, tell us a little bit about what it is that you do.
I am a workers' compensation attorney primarily. I work out of Gaithersburg, although my office has offices in Frederick and Lutherville. We represent injured workers throughout the state, primarily public safety, municipalities. We also do some personal injury, medical malpractice, trust and estates. So we're here to serve.
Jonathan, tell us a little bit about what it is that you do.
Yeah, David, as you know, I work with you and I work with Gretchen in the workers' compensation community. I work for the law firm of Friedlander Missler in Washington, D.C., and my entire practice for the last almost 9 years has been serving employers and insurers, self-insured employers, uninsured employers in both D.C. and Maryland. And that's been my entire practice for the last 9 or so years.
So, Jonathan, the workers' compensation, no one really thinks about it until you need it. Tell us a little bit about how this animal was created.
Well, certainly the history of workers' compensation isn't the most exciting thing in the world, but very briefly, until the early 1900s, workers would get injured on the job, as would be common practice then as it would be now. But back then there were a little bit more physical jobs like working on railroads and such. It was very difficult for injured workers to obtain benefits for their injuries. So around 1914, 1915, Maryland came up with the Workers' Compensation Act, and the primary benefit was to take care of injured workers that got injured during their time at work. But there was also a huge benefit to the employers and insurers as well. The main benefit that developed was there was one source of cause of action that could be brought against an employer or insurer when an injured worker was injured on the job. Rather than being sued in tort, negligence of that sort, they had to follow the rules under the Workers' Compensation Act, so it channeled the cause of action for an employer or insurer to only have to focus on one area of law to defend.
And Gretchen, everything now is online.
Yes.
How about the workers' compensation?
Absolutely, follows suit. So the Maryland Workers' Compensation Commission has a website that can be accessed by the public. It can be accessed by an injured worker, by an employer, an insurer, by attorneys, and it allows us to have some information about specific claims. You have to have access to that information. But for the general public, it gives information about what an accident is, how to file a claim, how the hearing process goes through, from the start to the finish, and it just gives some basic information. It's a great tool because nobody plans on being injured at the end of the day, and so it's a great tool if that happens either as the employee or the employer to kind of know what your rights are.
Jonathan, if I'm injured at work, can I file this whenever, or do I have to file it within a certain time frame?
Yeah, that's a great question. And that's one of the important answers to that question is why you need someone like Gretchen to assist you if you're an injured worker. Injured workers there are basically two dates in which they need to be aware of when they have a workers' compensation injury. They're supposed to file a claim within 60 days with the Maryland Workers' Compensation Commission. However, there are ways in which an individual can excuse themselves out of the first 60 days. The hard and fast rule is that any injured worker must file a claim with the Workers' Compensation Commission within the first 2 years. And if they don't file a claim within the first 2 years, by and large, they are barred from bringing forth their claim any further. And the employer insurer, the folks that I represent, would not have to defend that claim. And again, that's why it's so important that injured workers make sure that they obtain counsel like Gretchen to know what the rules are and when they're supposed to file their claims.
Gretchen, do I need a lawyer? Can I
Absolutely.
do this myself?
Absolutely.
Why do I need a lawyer?
You need a lawyer because nobody plans on getting hurt. So at the end of the day, you get hurt on the job, the only responsibility that an injured worker has is to report the accident. A lot of times when they report the accident, the injured worker thinks that they have a claim on file, and that's just simply not the case.
When you say report, you mean telling their employer?
Correct.
But that's not enough.
That's not enough.
What should they do?
What they should do is tell the employer that they had an injury. The employer will then file a claim. What will happen is they'll file a claim with their insurance company. So just by way of background, just like you and I, to legally drive down the road, we have to have insurance on our vehicle. Unfortunately, if we get in a car accident, and let's say I hit you, never happened because I'm a really good driver.
I don't believe you.
You might hit me. You hit me, I file a claim. I notify my insurance company. I'm not paying, or you're not paying me directly because you struck my car. It's the insurance company. So similarly, in a workers' comp case, if an injured worker, regardless of fault, gets hurt, they're in a situation where they report the claim. The employer is then going to report to their insurance company. The reason that you need an attorney, or anybody who's been through this situation should get an attorney, is because a lot of times they think that that's a claim right then and there, and it's not. By law, under the rules or the law of Maryland workers' compensation, an employee has to file a claim within 2 years, just like Jonathan was saying, for it to be filed under workers' compensation. If they don't, and let's say 5 years from now, 6 years from now, they're still having problems and they don't have that claim on file, Jonathan's client doesn't have to pay any benefits. So it's really important to have an attorney for that reason. And also, at the end of the day, you need to know the players, you need to know what your rights are, because the insurance company is never going to tell my client what their rights are.
If the claimant is insistent that they don't want a lawyer, are they required to have a lawyer?
They are absolutely not required to have a lawyer. What will happen is, as long as that claim, if people hear nothing else from today, or at least injured workers hear nothing else from today, the most important thing is to get a claim on file with the state of Maryland, the Workers' Compensation Commission. You can do that online, you can get the paperwork, and you can file it by mail. You are not required to have an attorney. My recommendation is that you do have an attorney, because what will happen is the insurance company will take a statement from you. The insurance company will be responsible for authorizing treatment. The insurance company will be responsible for paying any benefits that you're entitled to under the law. To be able to receive those, however, you have to have medical documentation and have evidence. Jonathan here is going to fight that on a good day. He's going to fight that, and until you go through that process, you're not going to know what to expect. An attorney is going to know what to expect. If at any point in time, regardless of whether you have an attorney or not, you're in a situation where the insurance company is not authorizing treatment, we go to a hearing before the Workers' Compensation Commission, regional sites all throughout the state. There are a lot of unrepresented claimants at those hearings. And what will happen is their case will get called. The commissioner will call their case, say, hey, do you have an attorney? They will give them their rights, tell them that they have the right to do so. They'll give them the option to try a case by themselves, but they will urge them to get an attorney.
And if you don't like your lawyer, can you get rid of your lawyer?
Certainly can get rid of your lawyer. Here's the deal. The attorney-client relationship is based on trust. If at any point in time you don't feel like your client is, or your attorney is providing the representation that you feel that you need, you have every opportunity to terminate their services. My recommendation from a procedural standpoint is that you speak to your attorney. Not only call them up, but have a meeting with them. Because a lot of times there are misunderstandings on what the law is, what you're entitled to under the law, and what your options are. And so, but at any point in time, if you feel like that attorney is not giving you what you're supposed to be receiving or what you're entitled to under the law, you have the right to fire that attorney and seek other representation. Whether another attorney is going to handle the case is a different story.
Right. Jonathan, a lot of your clients may not have insurance, not a lot, but many don't have insurance, and often through no fault really of their own. So if I have a homeowner's policy and I hire a nanny, do I have workers' compensation coverage? If I'm a contractor and I have a commercial policy for a liability, do I have workers' compensation insurance, or is that a different animal?
It is a different animal, and they are very separate and distinct. And if there really is one thing that I would want to get across today to any employer, whether you employ one individual or 30 or 40, it is critical that you have workers' compensation insurance. And primarily where this comes up with uninsured employers are with the smaller companies, the smaller mom and pop shops.
And the nanny situation.
And that situation just like that. And your homeowner's insurance does not cover workers' compensation. You do need to speak with a private insurance company. If you're a company that's large enough that has an agent, you speak with your agent. You want to make sure that you specifically sign up for workers' compensation insurance so that you don't get into a situation where someone gets hurt who you are employing and you're stuck, you don't have the insurance, and then you're potentially subject to penalties and other issues.
It's not even that expensive, is it?
It is not. And it is the cost-benefit analysis of making sure that you have workers' compensation insurance is a no-brainer. And every employer needs to have one.
Moving on to what is an injury. So briefly, tell us what an accidental injury is.
So the Workers' Compensation the Workers' Compensation Act in Maryland covers accidental injuries that arise out of and that are in the course of one's employment. And you could kind of break each of those pieces down, but to very simply state what is covered under the Workers' Compensation Act are injuries by a worker who was very clearly performing their job at a particular time, at a particular moment for their employer, and they were doing something in which they sustained an injury. And so long as that's something that was done, there's a very clear connection, a causal connection between what they were doing and the injury that they sustained. So long as that happened while they were working, that is covered under the Workers' Compensation Act.
Gretchen, what's an occupational disease? And actually, you also do public sector work.
I do.
So how is that a little bit different, and what is public sector?
Okay. So here's where it differs a little bit. Accidental injury, you slip, you trip, you fall, you know specifically when you had that condition. Occupational disease can come in many forms, through repetitive trauma, through certain conditions that you develop through work. And a great example is somebody who does a lot of repetitive typing, a lot of manual labor. They develop carpal tunnel. There isn't one specific time that you note that you had that problem, although you can under an accidental injury, but you just continuously are typing or continuously repeating certain motions and you develop carpal tunnel syndrome. That's an occupational disease. Under the law in Maryland, to have an occupational disease, you first have to have the diagnosis. You have to have a doctor relating it to your work and say that this is caused by or contributed to by your work. And then you have to have some sort of disablement, meaning the doctor has to say, listen, you can't do that work because of this condition. Ideally, they take you completely out of work. However, we've been successful at times and with the doctor saying, listen, I don't want you using your hands repetitively in this situation. If you can maybe have software whereas you're not typing, that is considered disablement. From a public safety situation, public safety members in Maryland, firefighters, police officers, correctional officers, any sort of first responders are covered under a different type of law. They have all the rights as an accidental injury. They have all the rights of an occupational disease if they develop such as carpal tunnel or some sort of situation like that. There is also a presumption, however, for firefighters and police public safety. The presumption laws are designed to protect our public safety members. A lot of these public safety members, or the majority of them, do shift work. And because of that shift work, they develop certain heart conditions, hypertension, heart conditions. Firefighters, unfortunately, are exposed to many different types of carcinogens and develop different cancers. And Maryland is one of the leading states in the country to have developed these presumptions, whereas all that we have to prove for these public safety members is that the condition is, the work is a factor of the condition. And it's designed to protect those individuals who protect us. So we're ahead of the game in comparison to many states.
Jonathan, let's say I'm an injured worker, and I don't do it intentionally, but I wasn't so smart either. And I caused the injury. Am I covered? Not
Or
covered?
you're a klutz like I am.
Or you're, yeah, kind of a klutz.
You are covered.
Even if I'm at fault?
Yes, even if you are at fault. And that's one of the beautiful things if you're an injured worker that we have with our workers' compensation laws. It's something called strict liability. It's no fault coverage. So, you could do something entirely incorrectly against a policy of your company. And if you were injured on the job and performing your job, you would be covered under that.
How about if I show up to work drunk?
Now that's a different scenario. There are some exceptions, and intoxication, drug use would be one such example that would take you out from underneath the coverage of the Workers' Compensation Act. So if you do show up to work drunk and you sustain an injury while you are intoxicated, you would not be covered under the Workers' Compensation Act.
How long does the process take? Just run through what it is that an injured worker might expect if they actually have to go through the workers' compensation process. Where do they go? A hearing? What is it that they do?
Yes. So as Gretchen was describing initially, you sustain an injury. There's a period of time in which you are to file a claim, and at some point there may become an issue where you believe that you are entitled to some additional benefits than what you are receiving if you're an injured worker, whether that's medical benefits, whether that's indemnity. By indemnity, I mean monetary benefits. And what happens at that point is that you would file issues with the Workers' Compensation Commission, which would generate a hearing date, and then the parties would present before the Workers' Compensation Commission, Gretchen and her client, the injured worker, and I, on behalf of my client, the employer and insurer, and we would litigate the issues before a Workers' Compensation Commissioner.
Judge.
A judge.
And do you get a decision right then?
You do not. Decisions can take, depending on the commissioner, there's no specific time frame, but decisions can take anywhere between a few days and probably a few weeks.
If I don't like the decision?
If you don't like the decision, you can always appeal. So in the state of Maryland, your initial stage is to go before one of the Workers' Compensation Commission hearing sites. You try your case, and as discussed, within a few days or a few weeks, the written decision comes out. Whichever party does not appreciate that decision can certainly appeal it, and what you would do is you would appeal it up to the circuit court. And in that case, more often than not, it could be a bench trial in front of a judge, but more often than not, it's going to be a jury trial. And what we call these de novo jury trials. Essentially, you retry the entire case in front of a jury. You can present the same amount of evidence that you presented to the Workers' Compensation Commission. You could present less, you can present more. You have the opportunity to retry your entire case on appeal, and this time you're doing it in front of a jury of your peers.
Gretchen, let's say I go to a hearing. I'm an
Yes.
injured worker, and I win, whatever that means. But I'm not at work. What do I get?
So you're entitled to three main benefits under the law once the case is accepted. You're entitled to medical treatment that the doctor causally relates. So any treatment that the doctor says is related to your injury or your occupational disease is medically necessary and is reasonable. The insurance company is going to have to pay for. The next benefit you're entitled to is any period of time that the doctor says you're completely out of work. If that's the case, you're entitled to 66% of whatever you were making before the accident. The way that that's determined is they take the date of the accident or the date of the occupational disease 14 weeks beforehand, and they add up what you were making before taxes. Once you have that amount, they divide by 14 to get what's called your average weekly wage. Because workers' compensation benefits are tax-free, you don't pay taxes on any benefit you ever get in workers' comp, regardless of the phase, you get 66%. Now, there are some exceptions if you're work for a certain employer or a certain county, but for the majority of the people who get injured on the job, they get paid 66% of whatever they were making before taxes. To be entitled to those benefits, you have to have a doctor writing you completely out of work. There's a certain exception where sometimes the doctor says, listen, you can work, you can't go back to what you were doing beforehand. I want you to do desk work, or I want you to work part-time. In that situation, it's called light duty. If the employer can accommodate light duty under the law, the injured worker is to work it. If the employer says, listen, we have nothing like that, or we can't really fit that in right now, then the injured worker continues to get their workers' compensation checks, that 66%. And then the last main benefit that a client or a claimant gets is at some point in time, if the condition, and it doesn't happen always, but if the condition is permanent in nature, meaning they didn't get back to how they were before the accident or before the occupational disease, then you're entitled to some permanency benefits. Those are based off of whatever percentage of loss, in part, whatever percentage of loss a doctor says you have as a result of that accident. Normally what would happen in that situation is I get a rating from the doctor, Jonathan would get a rating for his client, on behalf of his client, and we'd go to a hearing and we would submit our evidence, our doctor's reports, the treatment recommendations, or the treatment reports, and then the commissioner would make an award. And as Jonathan said, a couple days, couple weeks, maybe a month or so, we'll get a decision.
And Jonathan, let's say I get one of these permanency awards, which is a lump of money, right?
It is.
Usually. And 2 or 3 years later, it's really bad. It's getting worse. What happens then?
So that's what we call worsening of condition in Maryland.
Do you believe in that?
On behalf of my clients, no, I don't. But basically what happens is you have 5 years under the law from the date of the last payment that you received in order to go back to the commission and argue to the commission by way of medical evidence, as Gretchen just described, medical reports, medical opinions, that you as the injured worker has gotten worse since you were last before the Workers' Compensation Commission. In an instance like that, if the commissioner believes that the injured worker is now worse off with further causally related injury than they were several years prior, they can receive some additional permanency benefits, and there will be an additional award that comes out, and essentially that starts the clock running all over again, and this process will continue for several more years.
And Gretchen, as we wind down, just a couple minutes left, what if I can't go back to my old job and I don't know how to find a new job? What do I do then?
It's an excellent question, and it's a major concern for a lot of my clients. In the event that after the accident you've been treating and the doctor says, listen, you have permanent work restrictions, you can't go back to work to the job that you have, the first question that we ask, and that's usually when I pick up the phone and I call Jonathan and I say, listen, I've got permanent work restrictions for my client. Can your employer accommodate those? Can your employer make some sort of job accommodation for them so that they can continue to work? Best case scenario, yes. Worst case scenario, in the event that they can't, the law is designed to protect the injured worker. The injured worker is going to not be left hanging. The law says if the employer can't accommodate and provide work, then there's something called vocational rehabilitation. And vocational rehabilitation is a program under the law that allows a claimant, a third party comes in, and there's a counselor that helps a claimant work on resume building, job search, sometimes education at different various forms, to help that injured worker find suitable gainful employment. Basically, the goal is to put them back to as close to where they were before the accident as possible. And during the time that they're in vocational rehabilitation, they get paid workers' compensation benefits.
Good. So as we wind down now, one final question. Do you get to pick your own doctor?
In Maryland, absolutely.
And you don't have to go to the doctor that they send you to, do they?
You do not. There are certain times that you do have to go to a doctor that the insurance company sends, but as far as your treating physician, you have every right to choose whatever doctor you want to.
Great, thank you. There's so much more we'd like to know about workers' compensation, but as often happens, we've run out of time. I'd like to thank our guests, Gretchen Rogers and Jonathan Marlin, for being with us today. We are grateful to them for taking the time to discuss workers' compensation issues with us. Let us know what you think of today's show and what topics you might want to see in future shows by emailing us at lawschoolforthepublic@gmail.com. Please join us for future shows in our Law School for the Public series. Again, I'm David Schoenfeld on behalf of the Bar Association for Montgomery County, Maryland. Thank you for watching.